Okay, so we're back again to talk about transactional lawyers and artificial intelligence. I don't have many slides in relation to this. In fact, I've only got one because I am a transactional lawyer, and I think I'd rather have a conversation with you than sort of go through that structure. I think that what we're going to talk about here overlaps with the earlier areas, particularly in relation to the TAR, so the Technology Assisted Review, which I think, even though we talked about that in the context of discovery and pointing that technology towards unearthing the needle in the haystack, essentially a large part of transactional work is what we call due diligence. And essentially due diligence is the exercise of understanding what it is that you are buying or selling or you are transacting about. So why don't we start at the beginning? What do transactional lawyers do? I call myself a transactional lawyer. I'm a general corporate and commercial lawyer. I've spent most of my time with a focus on mergers and acquisitions, so buying and selling things, and a sort of subspecialty in the technology space. And over the time that I've been practicing, I've seen massive changes in the way that we use technology in practice. But I think it is actually, again, as always with this, we need to think what is it that we are trying to achieve, and then what tools do we need to do that job? And is there a better technology tool for doing it, particularly in the context of what we're talking about this week? Is there a way of using artificial intelligence for that? And I think there are really 5 key areas, and the reading, not just me, by the way, the reading you've been given would suggest that there are 5 key areas in which AI is impacting the work that lawyers do. So let's start with, those 5 areas are the way we review documents, the way we analyze those documents or underlying pieces of information, the way that we do proofreading and settle and finalize documents, the way that we assemble documents, the way that we undertake due diligence just generally. And then the last thing I have on a slide is this question around ethical issues, because in relation to all of this, ultimately we're thinking about ethics. So we need to think about what is the legal work and where are the risks. And these, I think, are a little bit more hidden than they might be if we are thinking about criminal law and big data policing, for example, which is the subject of the last video. So what do I mean by document review? Literally, I mean the kind of work that you already do in law school, reading things and making sense of them. So that could be because you are on the other side in relation to a matter. So you're on a side. The other side has prepared the documents or first draft of something for your review. Now, as lawyers, our job is to make legal sense of that document. But usually, particularly in a contract sense, actually what we're trying to do is identify, does this contract record the agreement that my client wants to make? And does it meet all of the requirements of the law in order to form an appropriate contract? Interestingly, once we get out of law school, commercial lawyers, it becomes ingrained in you. You know, when you are at law school, you're studying contracts, so I need to know, is there agreement, which is made up of offer and acceptance? Is there consideration? Is there intention? Is there capacity to be legally bound? Is there certainty in relation to what the contract actually means? And certainty, of course, has different elements that sit with it. Reviewing a document, often our focus is actually, as lawyers, is identifying, does it reflect the deal my client wants to do, and what are the risks for my client, and are they acceptable risks? The actual legal elements, now clearly they're important, but they almost become second nature to us. We hardly even notice that we are doing them, or we're looking for them, but clearly we do. And the craft of actually undertaking a document review is about identifying, well, what are the risks that my client is going to take? If something goes wrong, what are the consequences of that thing going wrong? And even though it's not technically a legal requirement, part of what we're trying to do is assess commercially, does this make sense? Is this fair? Now, when you think about the huge volumes of contracts that are going on in the world, there are kind of two types of contracts. There are bespoke in-the-moment contracts. So I'm selling my power plant to your government, and is $1 billion transaction, and where there's a range of different things that are going on. The drafting and the detail in that is pretty bespoke. At the end of the day, the contracts themselves tend to run in the same way. They seem to go in the same order, and they have many overlapping provisions, but every element of a massive deal like the one I just made up out of my head would be negotiated in incredible detail. And often the contract itself, if you were to print it out, which very few people do these days, it would, take up a significant volume once you've added in, the engineering specs and the timetables of what people have to do and the range of it. Because essentially a contract is, for that kind of transaction, it's basically a list of things that people are going to do or not do and what the consequences are. But then when you think about that very bespoke contract, many of the contracts that you enter into every day are actually very standard. Now, you might remember in Australia, the Competition and Consumer Law specifically provides an unfair contracts regime that sits over consumer contracts, which the definition of a consumer contract is essentially a contract with a value under $40,000, but also the value might be greater than that if consumers are involved in the transaction. But the unfair contracts regime, it itself applies to standard form contracts. So what is a standard form contract? Well, the onus is on a person who against whom an action has been brought under the Act, claiming that there has been an unfair standard contract. The onus is put on the provider to demonstrate that it is not a standard form contract. The presumption is that a standard form contract is a contract that is not negotiated in any way. It's a take it or leave it contract where essentially a provider, so whether, say, it's your bank or your electricity provider or your internet provider or your mobile phone provider are really good examples. Yes, you can compare the different offerings that are made by those providers, but you really get the standard terms on a take it or leave it basis. And because they're not negotiated and because they are complex and ordinary people often don't read them in minute detail, we have this part of the law that is there to protect consumers in that requirement or in that situation, I should say, and it requires that, or basically provides that unfair contracts can be voided. So why this long explanation of this? I think because we have so many of these contracts. I think thinking about standard form contracts and the way artificial intelligence could be used in a transactional sense, the buying and selling of a mobile phone contract, for example, is a really good example. So what's happened is somewhere is a group of lawyers have settled the terms and conditions for a mobile phone contract. Probably an in-house team with expertise. It is quite likely, one would hope anyway, that they have considered the requirements of the law, and we'll talk about regulatory technologies next. But they've considered the requirements of the law and they have looked at what the terms and conditions need to be. Clearly what they're doing is allocating risk. So you throw your phone on the ground, it gets broken, that's your problem. But if the mobile phone that we sell you doesn't work for after a reasonable amount of time when you haven't actually broken it in some way or, treated it badly, then the law says we have to give you a warranty, that we have to fix it, we have to make sure parts are available. And so we'll put that in the contract, and we take on the risk that if it doesn't work when it's been treated well, and you take on the risk that if it doesn't work because you dropped it. So there'll be a range of other terms too about talking about availability of service and a range of different things there, but the terms will be pretty similar. One of the things that artificial intelligence could well be used on a data analytics basis is, as hundreds and hundreds and thousands of people are using these telephone contracts, it helps do the analysis to work out, well, what's going to be fair and, let's face it, commercial for us to offer. If we're going to say we'll have an availability of telephone service in 99% of the country, what does that actually mean and look like? Can we actually deliver it? Are people's phones dropping out? So we can do that analysis and work out whether we can offer 99, 98, 97. What does it mean if we have some kind of outage? So that kind of analysis can be done. At the really basic level, we can use document assembly for that kind of transaction as well. The salesperson puts in your details, puts in your phone number, spits out a contract that goes to you by email. That is happening automatically on the back end. It's not even particularly sexy or interesting technology, but it is absolutely vital to the way that we work. And then in that middle ground, you're finding that document assembly is a really key part of the way the transactional lawyers work. And law firms are looking for efficient and effective ways of collecting data once and minimizing the number of times that information has to be typed into a document. You might remember a couple of weeks ago I showed you a slide showing a handwritten mortgage, and then a fill in the gaps mortgage, and then a kind of printed out bespoke mortgage. That kind of document assembly has made enormous differences to the way that we work as lawyers. One of the projects that I'm working on at the moment in the law firm that I spend time in is looking at ways that we can just minimize the number of times that information has to be entered in when we're doing a mergers and acquisitions transaction that involves the transfer of shares. So if we know what the deal is going to look like at the end, we're using various forms of technology to produce flowcharts, to produce organization charts that show the structure diagrams, we sometimes call them, that show the entities that are being bought and sold and what the consequences of the various steps in a transaction might be. And then there can be many steps in a transaction, but I'm entering the data once in order to spit out share certificates, share transfers, update share registries, update forms that need to be sent to ASIC or to the trademarks office or to a range of different regulators that need to be informed and updated as various aspects of the transaction happen. And of course, to ensure that there is appropriate compliance with tax and other reporting requirements. So I've talked about document review, I've talked a little bit about document assembly, I've talked about analytics, I've also got data rooms and due diligence on this slide. Now, due diligence, I think I already said, is the activity of really doing a deep dive to understand what it is that you're buying or that you are selling. There's a number of online data room providers that basically, so back in the day, this subject actually gives me so many opportunities to show you how old I am. But when I started out in practice, a data room was in fact a room with data in it. So at the law firm, you would identify one room and companies would put together folders of information about the company that was being sold. So that would include, its information about its shareholders, information about its accounts, copies of material contracts. So the material contracts are the important contracts that give value to the business or through which the business value is recognised. It could include information about litigation that the company or the target company is being sold is a party to. It had employee records, and often these would take up a huge amount of space, right? And then what would happen is bidders, people who are interested in potentially buying the business, would come in under non-disclosure agreements or confidentiality agreements to look at the data and to basically make an assessment of the value so that they could make a pitch or make a bid to buy the company, and also to work out what warranties and what conditions needed to be included in the documentation to buy the business. In other words, working out what it is which risks they were prepared to take and which risks they wanted to backload back towards the vendor, the sellers of the business. Now, that is a very superficial and high level overview of what happens in an M&A transaction, because what we really want to do is think about, well, what can happen with technology in relation to due diligence here? Well, firstly, most of this is all happening electronically now. Secondly, it's happening online, which speeds up the process enormously, because two or more different bidders can be looking at the data at the same time and have no idea that they're looking at it. Back when I started, we used to have paralegals chasing around bidders to make sure that, they'd gone down in one lift well before somebody came up in the other lift well, so that they wouldn't accidentally see each other and we wouldn't inadvertently disclose who might be interested in buying the target. So the two or more is really useful. A lot of the technology that has gone into the analysis side of data rooms is actually really similar to the technologies that have been used in technology-assisted review in the due diligence sphere. So a data room will have a lot of data in it and will include some tools that will allow the bidders to do their analysis of the underlying documents. So to be able to do the financial analysis or search for the particular things they're interested in. What I find really interesting, and this could be one of the ethical issues that you might want to think about, is most of the data rooms now will feed back to the buyers information about what it is that the bidders are looking at, what it is that they're interested in. And because often that data can give us some information about how willing or interested they are to purchase, or whether they're just doing a bit of tire kicking. And this, it sounds a little bit passé when I say it like that, a bit superficial, but this is a really important issue. If the natural acquirer of your business is a competitor, you can be quite nervous about showing them a warts and all overview of the business that you want to sell, because if they don't buy it at the end of the day, they might be using that competitive information for nefarious purposes. So it can be quite a fraught process, to say the least. I know that some of the data rooms have been, because they've been in operation now so successfully for so long, they are getting into the point where they are using artificial intelligence to predict the level of interest of buyers based on how often they come in and out of the data room, or the kinds of things they look for and the kinds of questions that they ask. And so giving a kind of certainty score to the vendor so that they can understand how likely they are to be able to do a deal, which I think is a really, really interesting thing indeed. Proofreading. As I look at those words on the slide, I think I really wish I hadn't put that there. Maybe I should have put document drafting. And document drafting kind of sits between document review and document assembly. And I think there's a lot happening in this space of helping lawyers with the craft of drafting. So this is why I called it proofreading to start off with, because I guess I was coming to it from a practitioner's point of view. So writing a contract is it's actually, for my money, the best part of being a lawyer. I love drafting. I love taking that blank piece of paper and assembling a contract that reflects the deal or the transaction that my clients want to do. And there is, like anything, a kind of form to it. The most modern and interesting and exciting of music still works within a particular form and beat and pattern recognition. And you see with all good drafting, there is definitely a pattern to it. You have learnt enough about contract law and about the law generally to understand the importance of consistency and precision in the way that we as lawyers articulate the contracts that our clients want to get into. But what I found really interesting in recent times is the growth of the tools that will help you refine that craft. They're not drafting the documents for you, which a document assembly system might do when we're talking about standard documents that are in very similar, if not identical form, being spat out day to day. But they will do things like look for the ways in which you might use defined terms within your document and whether you're doing that in a consistent way. So we know that if you are in a document you're talking about, say you're talking about the non-disclosure, and then you use confidentiality rather than non-disclosure. The tenets of drafting would suggest if you use two words that mean similar things when you could have used the same word to mean the same thing, the law will assume that you meant something different by those two terms. Often it's just inadvertent, and particularly when lawyers are drafting by taking clauses from one old document somewhere else. So they're using very similar terms in some way. Tools that really highlight, pick those up, ask questions about that. Tools that will identify if you are cross-referencing back to a clause that doesn't make sense. I think that is quite useful. Tools that help you if your document has some kind of calculation in it. So, a provision that says that if there's a breach of warranty, what the payment would need to be and how it would be calculated, that check those calculations with real world scenarios to ensure that the work that you've done makes sense. I think that really is actually really useful and really helpful to lawyers, and really helps us grow our legal drafting skills. There's a lot happening in the transactional space. There are a lot of new tools that are coming out all of the time. The way that transactional lawyers negotiate agreements online now is vastly different. I think probably the one piece of software that I haven't mentioned that I think has really come into its own in the last little bit, and I know I mentioned in an earlier video, is electronic signing in particular. Ways of ensuring, so technology that ensures that the person who is applying an electronic signature to a document is in fact the person or the entity that we need to have sign that document, we need to see has signed the document. And really knowing when, where, and how the document was signed. Really getting rid of many issues that used to come up when there might be, a misspelling of the date or concerns about whether a document, who signed first, in other words, who's making the offer and who's accepting the offer. Those kind of issues technology has really taken away. And interestingly, the pandemic has really, and the way that we had to work during the pandemic, has really helped with the rise of the efficiency of a number of those tools that transactional lawyers use all the time. But I'm speaking too much. It's time for me to shut this down. One more video, very quick one it'll need to be, or I'll be well over time, where we will talk about reg tech. We'll talk soon.